1.
Good morning, everybody. It's good to see everyone, commissioners, Madam Justice, etc. My name is Rick Ladd, and I am the interim, emphasis on interim chairperson of the ADRC, and I'm going to try and keep us on track today so that everybody can get back to the business at hand. I think the first thing that we need to do is to review and approve the meeting minutes from April of 2021. Has everybody had an opportunity to look at those? Notice I didn't ask if everyone had read them, only that you had an opportunity to do so.
Thank you.
And if those have been reviewed, do I hear a motion to approve those minutes?
Chair, I move the approval of the minutes as presented.
Thank you,
Second
sir.
the motion.
We have a motion and a second. Is there any discussion on this motion? Hearing no discussion, if we could take a vote, all those in favor of approving the minutes as written, say aye.
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 All those opposed? They are approved. The second item on the agenda are the statistics for the Rule 31 mediator reports. And I've got those behind what I call tab 3. I want to make just a few comments having looked at those. They were rather interesting to me. I probably didn't pay attention to the extent that I should have earlier, but in the court type page, which is the second one in your outline, it appears as though about 78.2% of the mediations that are being conducted and reported are from state courts of record, which didn't really surprise me. I was happy to see, if you'll turn a couple of pages over, that in-person mediations, 52.6%, which we probably want that number higher, but with COVID and other factors, I can understand why it's not higher, at least as of now. And I fully expect that with people getting used to Zoom and Microsoft Teams and some of the other platforms, that there probably will be additional mediations conducted online versus live. On dispute type, you'll see where domestic relations is broken down into 4 separate sections. I wanted to find out what the total number of domestic relations cases were that were being mediated, and that number is 860 if you add all those types together. So it is clear that domestic relations cases are currently dominating the mediations in the state of Tennessee, with personal injury cases coming up a distant second at 463. And then lastly, I looked at the statistics by county for mediations. It appears to me as though they largely track the population size of each particular county, although Davidson is slightly higher than Shelby, even though technically Shelby is a larger county per population than Davidson County is. Any other comments or discussions we need to have about those particular statistics?
Yeah, Chair, this is Steve Shields. I've got a couple of questions.
Sure.
I'm curious about something, is that we have, I'm looking for another number, John, and that's this, is that when I take a look at the number resolved at 64.8%, then I go over and the total number of mediations in person is 52.6, and video conference is 20.9, 849 and 418 respectively. I'm curious, do we know of those, how many are broken down, resolved and not resolved? In other words, is the video conference all 418 resolved? Are you with me? Is there some
Yes.
way to break down how successful the video conferencing, or is the video conferencing 0 and it's all of the in-person? I exaggerate, but you get the point.
Yeah, that's a great. So as you know, adding this breakout for in-person video conferences is new just in the last couple of months.
Yeah.
So now we have that data. I'll have to get with tech and see if we can parse into that. We've never been asked that before.
Yeah, I'm very curious about that. I attended a judicial conference a number of months ago, and they were talking about how the video conferencing numbers were somewhat down, but obviously we've gone through. The other thing, Chair, to make one add comment when it comes to our annual workshop, I noticed that we have so much family that I think that in fact, probably the workshop needs to have some emphasis on family. And I'm glad you pointed that out, that those are domestic cases. Thank you, Chair. That's all my questions.
Thank you, Steve. And that is an interesting question, as I think your question goes to the effectiveness of in-person mediation and resolving disputes versus the effectiveness of pure video conference to resolve disputes. And I don't know that I've ever looked at any figures that compare those two, but that's a very interesting concept, and I'm glad that you raised it. Any other? Yes, ma'am, Sarah.
Yes, please, Mr. Chair. I'd just like to point out, when I heard you say it looks like family mediations are dominating in this state, I would like us to all remember that most of these numbers do not include CMC mediations for reasons we've discussed often in the past. We don't have to go into it now. But I can just say in fiscal year 21, so the same year that just ended in June, NCRC alone completed 934 mediations, nearly all online. And we, of course, are not in circuit or chancery court for the most part. We were in sessions and juvenile court. So it's just something to keep in mind. This set of statistics is taken strictly from self-reporting by Rule 31 mediators, which does not truly represent mediation in the state of Tennessee.
And Sarah, is it your belief then that if it reflected the true mediation numbers in Tennessee, then domestic relations, family type cases would even encompass a larger share of the total?
Well, I think this last year was anomalous. And so, speaking strictly from what I have seen, this last year, it probably evened out with civil, general sessions, landlord-tenant cases. But that was simply because the courts were able to partner with federal financial relief efforts. I suspect that those civil numbers are going to go down again. And so, yes, I would say we will definitely see that domestic relations continue to dominate. Historically, I know that we have always had between 60 and 75% of our cases in domestic arenas.
Okay. All right.
They tend to come from juvenile court, not circuit.
Yes, ma'am, that makes sense. Any other comments, questions about the statistics? If not, we'll move on to the AOC staff report. Mr. Jefferson.
Thank you, Mr. Chair. You should see the PDF that says Program Manager Report. There's not much here, but I'm just offering it kind of as a thought-provoking. I just want to let everyone know that, and those watching, of course, that the 2022 renewal season opens October 1. That's about 3 months away. And the regular season is October 1 to December 31. And then all mediators have a grace period for 90 days, and that's January, February, and March, where they're still in good standing, but there's an increased late fee. So reach out sooner rather than later to help us make sure you have CMEs on file. And to that end, awareness for the commission that we put in the course search feature, and that's where providers can request approval for a CME ahead of time, and then it's available to be searched by mediators in the ADR portal. And I'm highlighting that here with the orange box. You can click course search, and at the bottom, the mediators can know how much CME they have on file. And if they have a green check, that means they're ready to renew. And then this is a screenshot of the course search. I just pulled it right before the meeting, and there's an NCRC event, there's a TAPM event, there are TBA events, and then details about them. And if mediators have questions about the standards, there's a link to the rule and talking about how much is required. Any questions? Really brief, but that's our ADR portal, just a snapshot of what mediators have to use all the time. A quick update on the medical debt ODR pilot. It seems like it's a recurring theme, but that's because it's one of our priorities. As a reminder, it's down in Hamilton County. We have Erlanger Hospital, Legal Aid of East Tennessee, Judge Alex McVeigh, and the other members of the court in general sessions in Hamilton County are all involved. And Steve Shields and other mediators are involved. And that's my biggest update, is that we went live in April. We invited about 40 debtors or 40 parties to engage and use this platform. We can report about a 30% engagement rate, 30% engagement rate from that initial round, but very few actually used the platform. They engaged, but they didn't actually use the platform. They reached out more traditionally. So we're trying to learn from that and move forward. And then the second update is that July 29th, next week, we're going to have training for a group of our initial group of volunteer mediators, and that'll be held virtually. And then here's a few screenshots. And I'll pause for questions.
John, is that a lower participation rate than you all thought it would be? Or is it about right for a brand new program?
Well, we didn't have something exactly to compare to, because this is pre-filing and medical debt. But yes, we've read some other papers like in Arizona and Utah where the engagement rate was pretty low. But we're working with legal aid to kind of establish that standard, to say, well, they didn't use the platform, but otherwise they wouldn't have reached out to Erlanger otherwise. And we're going to try to compare before and after.
Okay, great. It's a great program. I know when I looked at it, I remember clients I represented with medical debt usually were not sophisticated enough to log on, get on, they just might not understand how it all works. And people are much more sophisticated now than they used to be computer wise, but seems like 30% is pretty good for a brand new program, but obviously we want it higher.
Well, and we found, to your point, Justice Lee, the provider has sent hundreds of snail mail invites and got very little response to be in this program. But that 30% engagement rate came from when they received emails. And on that email has a video from Judge McVeigh, and has more information about it through the email, and they can just click on links.
Okay.
And
good to know.
If one of the goals is to resolve this pre-suit, I mean, clearly the mediation program is incredibly important, but even if there is an independent outreach to the creditor, I assume that some of those or a number of those are getting resolved, and a resolution is a resolution. So I never would have thought about that had you said that, John, that would in effect spur someone to reach out to Erlanger regarding their outstanding debt.
Yeah.
Yeah, this is Steve Shields. Yeah, Chair. We're going to put that into, we've done an evaluation data form, and even if they reach out through the platform and then move to a live discussion or something, we're going to include that sort of data. We consider that a success. That we're going to take a look at the number of invitations, and then once we invite someone into the program, then question is, all right, well, how was it finally resolved, either through the platform or through some other method? But I believe, John, we're going to consider that a success in terms of the number of people that responded to the invitation pre-suit.
That's right, because previously they had received at least 2 demand letters and hadn't responded, had been silent, and the billing process had been entirely complete, and they had been silent. So yes.
That's good.
All right, John.
One more item quickly, and it's important. I just want to give visibility to the commission about 2 programs, 2 grants that we recently awarded to about 18 to 20 different organizations across the state. One's the Parental Education Mediation Fund, and you can see the organizations that received funding on the screen, and that little bit of a heat map gives you an idea of coverage for the state. We try our best to spread it out across service areas and different clients that are served, different services that are provided, and to cover the state. And then the next one is the Victim Offender Reconciliation Program. Of course, we know that there aren't victim offender reconciliation programs in all areas, but the statute is pretty specific on where the funding can go to. With these are our VORP programs across the state. Any of your questions, that was 112K and 246. There's a third one called Access and Visitation that we administer, and that's based off of the federal year, so it'll be in October. We'll be putting out the applications in the next couple of weeks. Any of your questions? That's all I have.
Thank you, John, very much. Any questions for John before we move into the committee reports? All right, Ms. Reed, you're up. If you could provide the report from the Credentials Committee, please. And you're on mute.
Good morning, everyone. We had a lot of applicants this time, and 48 of them are recommended for approval without dispute. And you can read all of them. They were in your, they're on the portal, they're in the packet, and batch list, all that. You're welcome to look at all that, but obviously, as usual, Steph and John have done a great job of going through these and following up. So I would like to make a motion for the 48 that have been recommended for approval be approved. And if anybody has any discussion, please let me know.
All right, and Ms. Reed, that was a motion for the approval of the 48 you discussed.
That's correct.
All right. Do I have a second to that motion?
I'll second that.
Thank you, Marcus. Any discussion on that particular motion? All right, all those in favor of approving the 48 discussed by Ms. Reed, say aye.
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 Any opposition? All right, ma'am, passed.
The next items involve applicants that had some issues. For example, the first one, and I think everyone understands the reason for identifying these applicants by number would be because we're talking about disciplinary violations, and it just wouldn't be right to have names associated with these while we're discussing them. Now, obviously, they're in the packet, in the batch list. You're welcome to review all of that. So number 158727, folder number 6, what happened was this applicant applied for family and with domestic violence designation. We deferred this at our last meeting because the education did not, the work history did not add up to full 4 years of full-time work experience. And that is required, as you all are aware. So of course, John and Steph followed up with this applicant, and when we received the new resume, we could add the work experience, and it did meet the 4 years. So we are now recommending approval, and I'll make the motion to approve 158727.
Is there a
Second.
second to that motion?
Second.
Thank you. Have a motion and a second. Any discussion on, it sounds like we're talking about robots when we use numbers, but I do think that's a better way to do things. It takes away personal identifying information that whether you consciously or subconsciously go one way or the other, I think that's the way to do it. So any discussion on applicant 158727 before we take a vote? All right, all those in favor of the motion made by Ms. Reed to approve this applicant, say aye.
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 Any opposition? All right, passed.
Number 159758, attached in folder number 7 to your materials, is applying for family listing. And this applicant had a history of 7 complaints. 6 were dismissed by investigations. 1 was a private informal reprimand, and it was 15 years ago. We want to follow up with these. We can't just overlook that. It sounds concerning. And so the explanation letter sent by this applicant was helpful in this situation. And the word that we're going to be using that the commission has decided is what we're going to hang our hat on for determining whether the BPR issues affect the applicant's ability is unsuitability. So we looked at all that and we are recommending approval of this applicant. I'll make the motion to approve 159758.
Is there a second? Okay,
Second.
I believe I received a second. Any discussion on this particular applicant? You know, one comment I would like to make with regard to bar complaints. They are obviously something that we should take seriously, but we also should take into account that there are particular specialties within the bar and without the bar, particularly within the bar when you're talking about BPR, where complaints arise more often than others. And again, we ought to keep that in the back of our minds when we are considering applicants who may have a disciplinary history, and also the time. I remember looking at this, 6 complaints dismissed and 1 private informal reprimand 15 years ago. So I think that's important that we look at that as well. So there being a motion and a second to approve 159758, all those in favor say aye.
Aye.
All those opposed? All right, ma'am, that passes as well.
The next one is 159815, folder number 8. Applicant is applying for family listing. There's good standing. We always have to have a report of good standing. There were 2 complaints in 04 and 08. The first was a private informal admonition, and the second was a suspension. Obviously, that's concerning. This applicant provided a detailed breakdown on the application, and no explanation letter was requested. We did not find unsuitability in this situation. I will say, just to give a little bit more information, it had to do with a timing of the updating their paperwork. A suspension is pretty concerning, but our recommendation is approval, and I would make the motion to approve.
So Ms. Reed, what we're talking about is a suspension for failure to pay dues or failure to report as required. Is that what we're talking about?
Steph and John, am I correct? I don't have that one in front of me other than your notes. Am I correct that that was what the suspension was based on?
So there was an initial violation, but yes, it was a summary suspension for failure to respond to the BPR. And then the attorney resolved the underlying issue and then worked through to get the CLEs complete and pay the fees.
Yes.
So yes, there was an underlying issue that was resolved and the board was pleased with it, but it was a summary suspension for failure to respond.
So Ms. Reed, are you making a motion to approve 159815?
Yes.
Do I hear a second?
Second.
Thank you. Any discussion on this applicant? Hearing none, I'll call for a vote. All those in favor say aye.
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 All those opposed? All right, Ms. Reed, that one passed as well.
Applicant 159810, applying for family. met the required duration of full-time work experience, but we were questioning the role as CEO and founder of a for-profit company. And then this is where we can get creative in helping people figure out what their credentials are. And when they provided more details about the applicant's role as a research assistant, it appeared that since the work wasn't required for the doctoral degree, it could count as education for the family law listing. And so we recommend approval of this applicant. I'll make the motion to approve 159810.
Do I hear a second?
Second.
Thank you very much. There's been a motion and a second. Any discussion on applicant 159810? Hearing none, we'll take a vote. All those in favor of approving 159810 say aye.
Aye.
Any opposition? That motion carries, Ms. Reed.
The next one is applicant 159820. The information is attached in the folder in your materials. Applied for general civil and family. We have to look at the full-time work experience, and so obviously the full-time work experience qualified this applicant for general civil, but we were having trouble finding how it would fit for family. There were only 2 out of 4 of the required years. So then we got a resume, and it showed that this applicant had 8 years of prior experience as an auditor for the Department of Revenue. And that is one of the categories. If you have 4 years or more in that, then it will count for the family listing. So we're recommending approval of 159820, and I make a motion to approve that applicant.
Do I have a second?
Second.
Any discussion about applicant 159820? Hearing none, all those in favor of the motion say aye.
Aye.
Any opposition? All right, motion to approve 159820 passes. Ms. Reed, it looks like the second item is a denial of renewal lapse appeal.
Yes, this is not something that the commission needs to approve or deny. We just wanted to bring it to the commission's attention that Steph and John go out of their way to help people with deadlines and giving them extra time. What happened on this one, help me out, John, if I don't get the facts right, but what I recall is that the applicant sent in the paperwork, but the payment did not come in on time. And there was an email chain that you wouldn't believe that our people helped this applicant. It was more than 30 days after the renewal time closed, and just couldn't get it together. And so we made a ruling that the applicant would not be able to be listed upon renewal because it was too late. And he or she appealed that. And there's not a real appeal process, but we allowed it to be considered a second time. And we went through all of the communication. We went through all the dates and it was something that if we felt that if we allowed that kind of lapse and length of time, it could flow into other applicants and having to go the extra mile that that long. So we did deny that. It's not something everyone has to vote for or against, but we just brought it to your attention. You know, we don't like to do that. I mean, the idea is to have as many mediators as we can, but there are rules and deadlines, and we just have to stick to those. So that's the information that we wanted to provide.
And as a neutral observer, I sat in on that committee meeting, and I can assure the commission that this person received due process with respect to this particular topic. Any questions regarding that particular issue? All right, revision of character reference form.
This was just something a little bit minor, but it was something that bothered me when I was reading all the packets from the applicants. So many times, as you can see on this form, the incorrect information would be put on this first line. So what we wanted was to make it really clear: mediator applicant's name, and then your name. We wanted both of those to be on there. It seemed unclear before because people were putting their name instead of the applicant's name. So we just made a small change on the form. It might not seem like a big deal, but it needs to be, it needs to be correct. And if people can have the right form, then I think it helps.
All right. Thank you very much. Anything else, Ms. Reed?
That's it for my committee.
Okay, moving on to the training and education. Let me digress for a second and say, one of the things that I have been able to observe since being appointed interim chair is the work of the various committees. And it's very easy to focus on your work in your committee. And it is truly astounding to see how much work the committees, the ADRC committees work, and the individuals work to enhance and foster ADR throughout the state. And you are all to be commended. I had no idea that so much time and effort was expended. And I'm going to have a few more comments about that at the end. But Lori, I wanted to say thank you very much. And obviously thanks to staff for assisting you in doing a very difficult job. And that goes to all of the chairs of the various committees. You work very hard, and I greatly appreciate that. And I can assure you that those who are trying to resolve disputes short of the court system, while they may not feel like they got a good deal at the time the mediation concludes, ultimately, I think, amicable, or at least as close as you can be, amicable resolution of these disputes is to the benefit of everyone. So thank you very much.
Thank you.
All right, Marcus, Training Education Committee. I'm sorry I interrupted you a minute ago.
Thank you, sir. Good afternoon, everybody from Knoxville. Hope everybody's doing well. A couple of acknowledgements. I just wanted to say personally thank you to Mr. John Jefferson, Ms. Stephanie Brake, and the entire AOC staff. Your hard work makes life simpler for me. I would imagine that everybody on the committee would say the same. So thank you for your hard work. And also to my colleagues on the Training and Education Committee, Ms. Leslie Gaddis and Mr. Charles Hill, thank you for your professionalism and hard work. So all the action items on the report on the agenda are what we, the Training Education Committee, went over on July 7th. I'm just going to go over by one, and Mr. Jefferson is going to chime in and help out with some context and some updates on a couple of key pieces. So, Mr. Jefferson, thank you for being my de facto point guard and assisting me on these matters.
I'm here.
All right. So the first item is the training waiver request, and we're looking at applicant 156971 on the attachment number 11, and applicant 158611 on the attachment number 12 in the packet of information they were sent. In that paragraph, it says, both applicants are applying for general civil listing and are requesting training waiver based on substantial equivalence. It looks like what we stated is we want to present a common question to the ADR, and basically saying on whether the ADRC will approve fully virtual trainings by non-pre-approved providers. So Mr. Jefferson, if you want to just step in a little bit and provide a little bit more context on that.
Absolutely. I think you said it well. This is a new question that comes before the ADRC Commission. If I can just remind us, right, we approved a hybrid pilot program and then a virtual pilot program that runs through the end of this calendar year. And at the same time, we have the ability to grant waivers for mediators who do another course that is substantially equivalent to what we require. But this is a unique situation because we don't approve any virtual training that's not part of the pilot program. And these two applicants have taken virtual only training from organizations in Georgia and then a national organization that were at least 40 hours face-to-face video, just like we require, and had very similar requirements as we require in Rule 31, but it's fully virtual and it wasn't part of our pilot. Pending your questions or follow-up, that's why we're presenting this common question, and it's brand new to us.
And John, was there any Rule 31 specific training in this fully virtual training program outside the pilot?
No, there wasn't, Chair. So that's one of the 12 things that are required. And no, one course was from Georgia, so there was nothing on Rule 31 there. And then one was part of an undergraduate program. So there was no Rule 31 training on that as well. And that's also an issue.
Well, let me start taking it apart in the chair.
Sure.
Is that first off, we did approve virtual trainings. Then though, we have the rule, and the rule provides that the training of someone in this state who is not taking an approved course must take training that is substantially equivalent of that we require. And so the question is whether they've been approved or not for virtual training. Is the training they receive substantially equivalent? Then the second one I understood dealt with somebody from Georgia. And then if they're approved by a mediator in another state, and I understand that person from looking at the file was in fact approved by a program that was approved by the Georgia State Commission, although they've discontinued the training, it was approved. There's a certificate in there. And so now to me, it gets back to the question again, was that training substantially equivalent? And so we know that in all likelihood, the national organization and the Georgia probably did not focus on Rule 31 and procedures. I think they both focused then on simply the model mediation rule, which is similar to Rule 31. I noticed in the material then where there was a reference to review the model rule. And so now the question is, in my mind, and I haven't looked at it that closely, is that even though it's not been approved virtually, the question now is it substantially equivalent? And I'll turn that back then to the committee. I mean, I've looked at it, but I think that we ultimately get back to that question then, Marcus Rudolph, is it substantially equivalent? I think that's my focus anyway.
Well, yeah, and correct. That's why we were trying to bring this upon to the committee, just to get a sense on where to go from here. I mean, I lean to Mr. Hill or Ms. Gaddis or anybody else in regards to their thoughts on it.
Mr. Hill, any comments, sir?
No, I think I was focusing on a different aspect of this, and that aspect was whether or not the fact that it was virtual training made a difference. I was not focusing on the point that Steve made. I think Steve makes a good point, and I'd be willing to listen to other folks' input on that.
Mhm.
Let me kind of summarize again. We changed our training by going virtual, but we didn't change the rule. And so Rule 31 says, no, wait a minute, it's got to be substantially equivalent. So now then the focus for me is that training substantially equivalent? And I've always noticed the content of the training talking about Rule 31. Probably if we require them to on Rule 31, and I've got some thoughts here, but if you require Rule 31, then obviously most out-of-state programs are not going to do that.
Correct.
I suspect. And so I turn it back simply for further thoughts about, to me, the question is it substantially equivalent? Obviously, it doesn't say identical.
And then, John, to me, one of the issues is you have these pilot programs. So you have this subset of virtual mediations. And are we going to apply the substantially equivalent requirement across the board or only to pilot programs that have been approved? Does that make sense?
I'm not sure I followed that. I'm sorry. The substantial equivalent in the rule that we're looking at would apply to both virtual delivery or traditional delivery.
Okay, including virtual delivery that is not within the scope of one of the pilot programs.
Well, and that's exactly at issue here, because neither of these two were inside the scope of the pilot program, but they were virtual.
I guess what I'm trying to get at is, do we look only within the subset of the approved pilot programs to determine whether or not they're substantially equivalent, or are we going to apply that standard broadly to non-approved programs? Because to me, that makes a huge difference, because it's going to be an application of substantially equivalent across the board, regardless of whether non-pilot programs are approved or not, or is it just that subset of the pilot programs that have been approved?
Chair, can I make a comment here?
Absolutely.
Let me draw a distinction, and I understand where you're going, but again, I'm going to look at Rule 31. The one is for those individuals who get their substantial equivalent, who are in this state, and who get their substantial equivalent. And so that's the only criteria there. And to me, is it substantially equivalent to our virtual pilot program? I mean, we have a program and it's got to be substantially equivalent. The second rule goes to the second person, and it says for approval as a mediator by another state, and such approval has been granted, and if the mediator is in good standing. So the second part of this is, if you're in another state, it doesn't matter if it's substantially equivalent or not. You must have taken a course that was approved and you got that approval.
Right. Number two is more of a reciprocity issue.
That's right.
Where one state recognizes another state's training program as equivalent to Tennessee's program to allow Rule 31 listing.
So that discussion's helpful, because that we took it reciprocity as in the person must be listed with another state, and then we recognize their listing under that. But this person didn't actually get listed in the other state. They brought their certificate here and applied to us. But that's good discussion. That applicant is not listed in the other state with the certificate.
Well, let me read the rule then, and I get it, but let's look at the rule real quickly. Then I'll provide it. If a trained mediator has complied with the qualifications for approval as a mediator by another state, and such approval has been granted. So what you're telling me is the certificate she got was simply that she had completed the training, but that this applicant never actually got listed in the state of Georgia.
And I think the way that rule reads with the conjunction and, it has to be both. It's
Yeah,
not
It has to be both.
simply training, but you also have to receive approval, i.e. the equivalency of our Rule 31 listing.
I'm looking at the Justice Center of Atlanta, and it only says that she was, it's like our certificate. So as far as I know, she never got listed in Georgia.
Correct, sir. Otherwise, we could have used this clause for reciprocity.
Yeah.
So Marcus, I guess the question comes is, does your committee have a recommendation with regard to either 156971 or 159797, the two individuals listed under the training waiver requests?
Well, at this time, I don't think we had a recommendation. I just thought we, in regards to bringing this in front of the committee to get a better purview of what to do. And we can always table it and have further discussion so we can come with a unified front for the next meeting or in regards to that.
It's a very important area. I mean, we need to have, I don't know that content neutral is the right word, but we do need to apply the rules as they're written until such time as
Sure.
the ADRC determines that they should be rewritten. Substantially equivalent, a lot of that obviously is going to be a judgment call. But my thought would be that we would get a recommendation from your committee as to whether we should grant these training waivers, and your conclusion, yes or no, and also a conclusion based upon the substantially equivalent language, and a multi-step process to make sure that the person fits all the requirements as you go along. So as we said in the Navy, do more with less.
Okay.
Well, Mr. Rudolph, Chair, let me make this suggestion then.
Sure.
Unless you've already done it, is that I think that we've taken care of the one out-of-state person. There is no reciprocity for that person. Secondly, here, I'm now going through the course description, but I haven't done it in great detail. Maybe it needs to be turned back to the committee to take that course description and place it next to the content of not only what's in the rule, but in our virtual pilot. Because one of those things is they must and have engaged in a mediation of at least an hour long. Justice Lee and I were at a seminar a while back in which what occurred was somebody said, I never saw a mediation. I didn't do a mediation in the training, and I really didn't engage. I didn't involve in a mediation until I actually did one. And that's, of course, is what we're trying to avoid. And so I don't know, I guess my point is this, I don't know if the content of this trade, which looks very good, by the way, includes all of those component parts substantially. And I would think that it would have to include at least a role play, although I think I saw something in the material that it did. So I would suggest that unless the committee's ready to make that recommendation now, that the committee then review then the course content presented by this applicant to see if it is substantially equivalent to both our rule content and our virtual requirements.
Mr. Rudolph, is that acceptable to you as the chair of the committee?
That is acceptable, Chair.
Okay.
Absolutely.
And Mr. Shields, since you've looked through that, and I'm not presuming to be the chair of that committee, but if you have any thoughts in that regard, since obviously you've taken the time to look at it, perhaps you could provide those to Mr. Rudolph and his committee for consideration.
Sure. Marcus Rudolph, I'll be glad to share with you my thoughts.
And I think
Thank you.
one of the issues that we eventually need to address is Rule 31 specific training. And that is, are we going to modify the rule if necessary to require Rule 31 specific training, assuming that that is not included in the original training upon which the applicant bases their request for Rule 31 listing. And I have my own thoughts on that. Perhaps that's a topic for another day, though.
Okay.
All
Okay.
right, Mr. Rudolph, I guess that means we can move on. And unless anybody has any comments or discussion, I don't think we need a motion for that.
No, sir.
All right. If we could move on to the 19th annual ADRC workshop planning, please.
There is another training.
There's
waiver
another
request.
there's another applicant.
Oh, I'm sorry. I thought
It's okay.
there was just
It's okay.
two.
It's okay.
It's a DV
No.
waiver. Mr. Rudolph, would you like me to take it?
Yes, if you don't mind, sir. Thank you.
Absolutely. So you should see it up on your screen. It's 159797. In the rule, there's language that allows applicants to meet the 12-hour domestic violence designation requirement by doing training and or experience determined by the ADRC to be substantially equivalent to the 12 hours. The committee looked at the full file, the resume, and the 7 hours on domestic violence and personal violence and interpersonal violence that was supplied, and the experience as an assistant state attorney prosecuting some of these crimes, including domestic violence, and determined that it did meet approval, or they recommended approval, that it met the substantial equivalency in 14G.
So, Mr. Rudolph, are you making a motion for approval of 159797 as far as the training waiver goes?
Yes, we recommend that 159797 be approved by the committee.
All right. Do I have a second?
So I second it.
All right. I have a motion and a second. Is there any discussion? Hearing no discussion, then take a vote. All those in favor of accepting the recommendation of the committee regarding 159797 say aye.
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 Any opposition? Mr. Rudolph, your motion passes.
Thank you, Chair. Next item would be in regards to the 19th annual ADRC workshop. I do believe that Mr. Jefferson has an update on the planning. Mr. Jefferson, floor is yours.
Absolutely. Thanks. We're about 90 days away. It's going to be at Lipscomb University in Nashville, Tennessee, and also live streamed virtually. It's, as you see up on your screen, Friday, October 15th. We're still putting together the pieces, but we're going to have at least 3 main sessions. Of course, we want to talk about what we've learned in conducting virtual mediations over the last year and best practices. We have some ideas for the second panel. And then the third, we always have to have mediation ethics. Right now we have Steve Shields and Cindy Eddinghoff here from our commission, and they'll be presenting. We're going to do a survey beforehand, questions that mediators would like answers to or discussion points on, and then we'll, I think, an engaging hour on mediation ethics. We're going to start a new tradition. We're going to plan a commission luncheon. We're going to hold the speaker under wraps for just a little while, but it'll be a good speaker. And we're going to do pro bono recognition and provide a networking opportunity as well. In the afternoon, we go into breakout sessions. We know about half of our folks are family and half are civil, and some are dual. And so we're going to make sure that the content is focused on the needs of the attendees. We have some committed speakers, but I'm not ready to put them up there. We're going to talk about employment law, family law, adoption and juvenile. Then in the second session, a landlord-tenant session with perspectives from all over, from landlord, from legal aid, from the court, and kind of a wide-ranging discussion about landlord-tenant issues and mediations. And then we're going to have a 6th hour that's going to be virtually recorded and available. We've received feedback through the post-survey last year and the pre-survey this year that folks want a lot more networking opportunities, and they'd rather not race through 6 hours to pack them in the day. And so we're going to have 5 hours of CLE and CME, and then a 6th hour that'll be available virtual. I'll stop and pending your questions, please put this on your calendar.
And if I could ask everybody a favor, I've attended several committee meetings over the last several days, but I do remember one of them, we had a great discussion about topics and also potential speakers. And I would ask each of you, and I will do this as well, that if you have an idea about either, and perhaps even focusing on some of the ones that are on the preliminary agenda, if you could please get those to Mr. Rudolph or Mr. Jefferson, that would be great. I mean, I wish everyone could have been involved in the discussion. In fact, I think that, Sarah, isn't that where you raised Justice Koch's name? I believe. And you know, things like that, I never would have thought about it. A great suggestion. So please, you know, put your own head together and if you would, please contact Mr. Rudolph and Mr. Jefferson with any ideas that you have.
We've been setting save the dates. We're going to try to move into pre-registration phase in August so that folks have advance warning. And then we know, we think we can support about 100 to 125 to a little bit more if we'll see. So we don't want people to miss out on the opportunity by not saving the day.
All right. Any questions of Mr. Rudolph or Mr. Jefferson regarding the upcoming workshop or where we are right now or where we're going? All right. Hearing none, if we could move on to the domestic violence trainer application.
Yes, thank you, Chair. As you see on the agenda, we have the listed applicant in regards to their request for domestic violence training. We, as the committee, looked at the information and thought that the applicant met the requirements. Thus, we are making a recommendation, and I'll be making a motion for approval for this applicant.
All right. Do I hear a second on that motion?
Second.
Any discussion? Would anybody like additional information regarding this particular candidate? Marcus, John, anything else you'd like to say other than recommended?
Just that Charlotte Fleming Mediation has been doing family mediations for several years. They even did one virtually as part of the pilot program recently, and that was successful. And I visited that, did a site visit and kind of answered some questions about Rule 31 for an hour. So I have no concerns here. And then as kind of information, they will be applying to do this virtually as well. So they'll make sure that they comply with all the requirements, the 6 requirements in the virtual pilot program,
So
assuming that this commission approves this.
to clarify, this applicant is a trainer. She was my trainer. She's awesome. But what she's done here is applying to be a trainer for the domestic violence. Okay.
Correct. She's currently a family trainer, Rule 31,
Right.
46-hour family trainer, but then to teach the 12-hour domestic, that's what she's applying for right now.
And that's what I took, Mr. Rudolph, your motion to be to
Yes.
apply, or excuse me, approve her for the domestic violence training.
Yes, sir.
All right. We have a motion. We have a second. We've had discussion. Any additional discussion? All those in favor of approving Charlotte Fleming Mediation for domestic violence training approval, say aye.
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 Any opposition? Mr. Rudolph, your motion passes. Virtual pilot trainer program application.
Yeah, this is just an update. CMC Knoxville sent out an application or submitted an application in regards to being approved as general civil listing and family listings for trainings for virtual pilot. And they have been approved for both. I wanted to just say, well done in regards to, I can only be biased for the folks here in Knoxville. They do a great job. All the CMCs, Sarah and Steve, all the CMCs do a fantastic job, but I'm a little bit biased. So I want to just give a quick shout out to the folks here in Knoxville, Executive Director Jackie Kittrell and staff Sharon Upshaw and Jen Comiskey do an outstanding job. So I'm glad they have another option or way to train properly Rule 31 mediators over here. So it's a good job by them and good luck.
Thank you.
Yes. The next item is the virtual pilot trainer program and the survey results that were done. So I'm going to let Mr. Jefferson again step in and go over the survey results.
Absolutely. Thank you. Thank you, sir.
Mhm.
I have it up on your screen. It's number 16. This is just visibility on the survey results that we now require. Just to refresh your memory, when we launched the pilot for virtual and hybrid, we said, please fill out the survey, but we get very minimum, just a few surveys. But as a result, this commission said, well, before you issue a certificate, if you want to be part of the pilot program, you must fill out the survey. Then you issue the certificate. And that dramatically increased the number of surveys we received. You see 43 plus 35, that's 78 at least answered this question. So you have, did the trainer provide you with an opportunity to conduct a role play as a mediator? You have all positive answers. And then, did you feel the experience of acting as a mediator online was an effective learning experience? All positive. I won't do that for the other questions, but you have them in your materials, and then I'll pause for questions.
John, in going through this, did you see any cause for concern? Anything that could be done better? Anything that we as a commission can look at or consider looking at?
Well, I'll keep my eye out for it, but most of the time it came down to, well, there were some technical issues, but we overcame them.
Okay.
But I think we've discussed that the trainer has to do a pre-technical rehearsal with the attendees so that it doesn't detract from the 40 hours or the 46 hours, to make sure that everyone's on the same level technology. That's really about all I've seen.
Okay. Well, that's good. I mean, that's better than a substance issue.
I always wonder, because they had to, the survey respondents had to put their name and their phone number and their address. And I always wonder how that impacts their opinions as opposed to anonymous. So that's something we could wrestle with in the future. If it was anonymous, would the answers be a little bit different? But this is very helpful to us as well.
I expect that they would be, and I think that's a good idea, because we can learn a lot from criticism, be it constructive or otherwise. All right, number 6, new language on methodology.
Yeah, this was a situation where there was, if John can step in regards to just a refresher, but this was in regards to changing up some language in regards to our virtual program. John, you want to give just a quick refresher on the situation?
Yes, I tried to pull up the requirements of the virtual pilot program right there.
There it is. Yeah.
The trainer may not use in excess of 3 hours of pre-recorded material. And then there were some questions from a trainer in East Tennessee. What does that mean? And can I use additional hours outside of class? It got a little bit confusing, but and then it was thrown back to the committee, and they made a recommendation that they replace the virtual pilot requirement number 5, which is trainer may not use in excess of 3 hours of pre-recorded material. Instead, suggest trainer shall ensure at least a certain percentage of the training material is instructor-led for the attending participants, whether that's 80 or 85 or 90%, instead of saying only 3 hours. Over.
Right. So we just wanted to provide that recommendation and see if that was suitable for the committee, and go over however percentage that you want to list to be acceptable. And I do want to hear from Mr. Shields, because Mr. Shields did bring this up back in our quarterly meeting in April. And thank you for keeping us on our toes, Mr. Shields, that this was not resolved back in April. So I just want to make sure that Mr. Shields has a chance to also step in and talk about that as well.
Yeah, let me take this language here apart for just a second. By way of background, of course, what my concern was when I proposed limiting the pre-recorded to 3 hours was what I'd actually heard at least one trainer say, oh gosh, I can now put up all of these recordings. The other thing that has occurred since we spoke about this is that I can go online now and I can get 40 hours of training right now recorded. I mean, there are all sorts of programs where you can go on and get 40 hours of recorded. So that's why I wanted to limit it to 3 hours of pre-recorded. Then the next issue that came up was, well, there are some recordings that we can do synchronous. In other words, then if it's asynchronous, somebody puts up a recording and they go, here, go watch it. And it's not instructor led as such versus synchronous. Now then, can I get the language back, John? I need to take the proposal apart just a bit, okay? The proposed language. Here is my discussion with, and I saw the letter from Jackie Kittrell. And obviously you all know I know Jackie and we're both trainers. And so my discussion was this: I still have those concerns. And so, and I come at this from a little bit different angle, because if you say at least X percentage of training material is instructor led, training material, obviously I assume, what if it's all recorded and it's, led by the instructor? Let me back up and be a little bit more specific. Sorry, is that my thought is this, is that let's say there's 20% that you can use in recording, but out of that 20% of the 8 hours, only 3 hours you can simply have the folks view asynchronous. Here, go watch this. Or you can have 8 hours of synchronous or 5 hours of synchronous. I'm not sure I'm saying this well enough, but I'm wanting to place some limit, I think, in view of the opportunities that somebody can reach out now and simply say, here you go, we're going to watch this recording and I'm going to be present and we'll talk about it at the end. And look, I realize there can be abuse of the training programs, but that's what we're trying to do, is to place some limitation on it. And so I'm delighted now to have further discussion about this, but my thought is that if we took a 20% number and said, all right, 20% of the 40 hours, that's 8 hours. Of those 8 hours, you may use recordings of whatever nature you think is good training material. And all that 8 hours can be synchronous. Or if you want to use asynchronous, that can only be 3 hours and you have 5 hours remaining for synchronous. Now, I did discuss that with Jackie Kittrell, and we seem to think that might be one way to look at it. But I'm open for discussion. I know there are other trainers on here, and the evil I'm after. The evil I'm after is somebody really just pulling out all of this information and saying, here you go, watch it, because there's just all kinds of modules now about mediation.
Right. Well, other comments from anybody on the committee on how we should approach this?
Well, I'll chime in. It was my idea to change the focus from a limit on how much pre-recorded material could be used to a focus on how much instructor-led we wanted to require. So I was not looking at the synchronous versus asynchronous portion, but simply looking at putting the emphasis on what we wanted as opposed to what we didn't want. And I'm certainly open to what Steve proposed. That makes sense if you want to say, okay, for that 20% or 15%, whatever that number that turns out to be,
right?
For that number, so much of it can be synchronous and so much has to be asynchronous. I think that's a reasonable approach. I'd be interested in hearing from Sarah and other trainers what they think about it.
I would agree. I think that we definitely want to refine the language for people who want to follow the letter of the law, because it's certainly, I think, reasonable, even during in-person training, to share a 15-minute video clip as an example and then initiate a conversation. Well, one wouldn't wish that to somehow suddenly be potentially reprimandable pedagogically. So I think, but I think you're right to focus on what we do want, and what we want is synchronous education, right? We want people to be learning together, and so that people get feedback. So yeah, limiting the asynchronous work, I think makes the most sense, and it can be async. I mean, it could also then be go read this, go see this, go watch this, go do this, and report back.
All right. Any other comments?
Well, I was going to say, as lawyers, when we are required to report our CLE, and this is outside COVID pandemic considerations, I think the term uses simply live. In other words, you're limited about how much you can watch on TV versus how much is a give and take. And I just wonder if you use language, X percentage of the training is live and instructor led. Does that take care of the problem? Because it worries me the way it's phrased right now, especially the word material. It's a little bit confusing. Material to me is here's your notebook. Even though you can read material as the substance of what's being conveyed. And do you solve your issue by saying that, for example, 85% of the training must be live and instructor led? I'm not a trainer. I just throw that out for
I
consideration.
think you do, because that means if I'm conducting a live session and we're all together in real time and I show a 15-minute video clip for discussion purposes, that is acceptable.
Well, let me go back, and I don't object to that. I'm just, my point is this, is that how many times could I do that? Here's a 15-minute, here's an hour. And yes, I'm commenting, I'm with the students, and then we do it the next hour, we do it the next hour. And so the problem I'm getting to is that how much recording can you use as opposed to interacting like we are now? And my thought was that the recordings, okay, the TV that you're watching, so to speak, is that be limited to 20%, or in other words, 8 hours. You can have 8 hours of that, and you can have all 8 hours, Sarah, just like you said, as instructor led, or out of the 8 hours, if you want 3 hours, chair, as you pointed out, of just simply watching or going to read something, and you can have up to 3 hours. But I think there ought to be some parameters.
I find that a little infantilizing, though, Steve. I mean, I think until we see people egregiously abusing something, I think that it's not necessarily important to try to clamp it down in advance.
Here's my one last comment, and I'm okay with the other approach, is that we're probably never going to find out that people are egregiously doing it. It probably won't happen. What I'm trying to do on the front end is put up a deterrent, because I think, and I like your word pedagogically, I think a live interaction of what we're doing now is much more effective than simply, for 40 hours anyway, what?
Okay, but I'll just play devil's advocate and say we are still in a cultural learning curve here, right? We all learned last year that we could do things and learn things and communicate things effectively online that 2 years ago we would have sworn were impossible.
Well, Sarah, I'm not complaining about that. I'm not saying that we don't do this. We continue. What I'm talking about is whether it's this format or if I'm physically present. If I am physically present in a room, what I'm suggesting is that trainer, even physically present or live like we are now, either context, that trainer may not use more than 8 hours of recordings.
Sarah, can I ask you, what would your, and again, I'm not asking for a finished product, I'm just trying to grasp concepts here. What would your proposed language be? What it is now, changing it to something else? And if it's changing it to something else, what would your proposal be?
No, I think I appreciated what you suggested about you know, or your example of what's used in legal language, just saying that a certain amount has to be live and instructor led, and there can be a certain amount of asynchronous material. I think that if we simply say we'll limit asynchronous material and trust trainers to figure out what works and what doesn't, we can continue to see what, and it's not, I mean, I can't imagine even using 8 hours of recorded stuff. So it's not that I think that I know that we need more. I just feel like trainers should not feel that we're bean counting at that level. And yeah, it feels, I guess as a former teacher, it feels like too much oversight without a real understanding of what the problem ultimately might be. We don't know if anyone would even think of using more time than that.
So
I'd just rather wait and see. That would be my inclination. I'm not going to die on this hill. It's fine. We can say don't. Yeah, no more than 8 hours recorded. It just kind of, I find it to be kind of an irritant as a trainer.
Gotcha.
Yeah, I didn't want to kill a person's ability to use. I've seen some very, very effective recorded material. I want to use scenarios that have been recorded. I want to interject those things. I don't want to put a damper on people's ability to be creative and bring a variety of things to the table, whether it's pre-recorded or whether it's something that they found on YouTube or whatever. If it's effective and it makes the point, I want people to be able to use that. And I think we should have some limits on it. And that's why I suggested placing the limit on the other side of the table. Make sure that the bulk of the training is instructor led. And then you can use whatever you find that's really good and it makes the point. That was kind of where
I think we're trying to find a balance here among all of us in terms of, I'm always looking for, the abuse that could occur, only because I heard an instructor tell me that I can now start doing almost 40 hours of this and then with all the material. So I would suggest then, Chuck, let me try this, is that what if we put in, I'm going to propose that percentage number be 20%. That's 8 hours.
I can live with that.
and the corollary to that would be 80% has to be
80%.
live and instructor led, correct?
Correct.
And then the question is, do we want to phrase it in the negative or do we want to phrase it in the positive? And it's a very interesting questions about vignettes and the like that would be played. I see that as live and instructor led. To me, the problem comes like you have a substitute teacher in your history class and she says, I'm going to put on a movie about the Napoleonic Wars. I'll see you in an hour.
Right.
To me, that's asynchronous, I guess would be the right word.
Yeah,
So,
I think you hit it on the nail. You hit the nail on the head.
okay. Do you want to make a decision now? I don't think a subcommittee is warranted, but I do think it is very important, Mr. Rudolph, for you to receive input on this particular issue from Steve and from Sarah, and perhaps come up with a distinct proposal. And if you'll look in the chat room, John has put some up there for consideration. And perhaps your committee, Mr. Rudolph, could make a hard and fast recommendation for our next meeting as to one, sure, is change necessary? Sure. And number two, if change is necessary, here's the consensus. Sure. If you can reach consensus, and if you can't, then maybe it's a matter for the full commission to determine.
Yeah, I think that's
Mr. Chair, may I propose an additional person be added to that list of people that we talk with? I think Jackie has been involved at some point. Yes. And Steve asked for consideration from Jackie. And I didn't quite understand her response. So I'd like to hear from her on this issue as well. So she doesn't.
Absolutely, Mr. Hill. Absolutely. Yeah. So Sarah, Chuck, Steve, and Jackie. Is that correct?
Correct.
Okay. If you all could communicate with Mr. Rudolph, perhaps you all could have a short telephone conference to discuss how this might be modified. And then Mr. Rudolph, if you could be prepared to make a definitive proposal to the commission during our next meeting, or inform us that we can't reach consensus.
Absolutely, I will. Absolutely.
All right. Any other discussion about that? Does anybody else want to have input into this particular issue? Again, I don't want to speak for Mr. Rudolph, but I'm sure he would take an email suggestion from anyone.
Let me raise one issue that the language that was proposed to replace, I think it was item 5, the language that that John showed us had a blank for the percentage. And we have talked about 80 as though that's an acceptable one. That certainly works for me. I think 75 would be an absolute minimum. And I think 80 makes sense. And we've talked during this session, like 80 is kind of our consensus. I guess I wanted to get a sense of, are we all comfortable that that's the number that kind of seems to work here?
Well, I absolutely agree with you that I think anything below that, I understand Steve's methodology and it makes sense to me. Although the two, not one, but 2 40-hour programs that I've attended, I can't imagine that more than 1 hour per each one of them was asynchronous. So, 85% would not give me heartburn, nor would 90. But again, I'm not the one with experience, and I realize that.
I definitely think, in my opinion, 80% would have to be a minimum, in my opinion, but I'm not a trainer.
For those of you, excuse me.
Maybe that's something that we also ask that small group to.
Yes, sir.
Recommendation on.
I think that's a great idea.
Okay. Well, we can table that and go over that and make sure that everything is fine-tuned for the next quarterly meeting, and I'll present those findings to you and to everybody. So.
And Marcus, I'll be looking for even more assignments to give you.
Wonderful. Okay. Well,
all right.
If there's nothing else, and then that is the conclusion of the report for training and education.
Thank you. Again, as I told you earlier, Marcus, I greatly appreciate your work. You have expanded my mind in the way that no mushroom could.
My pleasure. My pleasure.
And yes, I do realize we're on YouTube, and that will probably come back to haunt me. But if we could move on to pro bono mediation and advisory joint committees, Mr. Shields.
Yeah, first off, I want to thank the pro bono committee members and the advisory committee members for the work that they have done and for the work they did during the meeting. And also thank you, Chair, for attending very much. And of course, we've always got to thank our great staff. They do just such a great job. And so thank you, staff. We appreciate it very much. You know, last November, we started with the Tennessee Supreme Court ADR plan with the expectations that we were going to have a flood of cases. That did not occur. And so we started attending then the judges' conferences in the hope that communicating them the plan itself and the right that they have to order mediations would increase those numbers. Those numbers didn't increase like we thought they would. I then, at Justice Lee's invitation then, as I recall, attended the Tennessee Judges Judicial Annual Conference. And it was a fun presentation. There was a lot of questions that were asked. And so Justice Lee, what I did when I met with the committee with all of the CMCs, I asked the question following that, was there an increase in referred cases? And the response was no, not really. And so as a result, then we started talking again about ways to reach out, and sort of the committee's idea is that we're just going to have to set up meetings with individual judges now and actually go meet with them, discuss with them, go through the process, because maybe one thing that the judges don't understand, some understand it very well. All they do is send us the file. We'll let them know whether or not it's been off their docket or not. And so there is not much work at all for any one of those judges to do. And so as a result, then we are going to meet again and be talking about the meeting, and of course, welcome your thoughts, Justice Lee, but it did not have what we thought would be the impact that we thought it might have. And so that's one thing. The other thing that came out of it, and I'll be sending this to you.
Let me interrupt
Yes.
a second. You know, I
Go
think
ahead.
you've done everything you can to increase participation. I don't know what more you could do except perhaps meetings with individual judges where there is a demonstrated backlog. I talked to several judges at conference about backlogs and are you handling it okay? Do you have a big backlog? What can we do? Are you using the plan? And what I got from basically everybody was we don't have much of a backlog. We're doing fine.
Huh.
And I don't have any data, to corroborate that or support that. But I just was almost consistently told we don't have a problem. Because I'd said, do you need more mediation? Do you need senior judges? What can we do to help? And basically, we don't need your help is sort of what I got in a really nice way. So I don't know if the backlog is what we thought it was going to be. Maybe that's the reason. And I don't know if John, if we have any way of knowing backlogs or, where the backlogs are. What was explained to me is that everything just slowed down during COVID so much that cases just weren't getting as many cases filed. But I still think the ADR plan is exceptional and really needs to be used. So anyway, I just throw that out as some information I picked up at conference because you gave a tremendous presentation, very convincing, and so I don't know.
May I say
Sarah?
something here?
Yeah, Sarah.
What I found to be kind of fascinating is that we decided after a couple of these big presentations when we got crickets in response to actually reach out one-on-one to specific judges in counties that were not otherwise served by a mediation center. And every single time, when I had these conversations, I heard the judge say, yeah, it sounded very interesting, but it really won't work. It can't be for us, right? My people can't afford it. They can't. And it's like, I had the sense that there are judges in, let's say, comparatively under-resourced counties who are so used to not being served by extra resources that they just don't believe it. It's easier just to kind of stay on track. And when we said, no, actually, we did mean this for you. And actually, what we can do, if you tell me how your court works, we can do this. And now, as a result, and I'm thinking, Houston County, Hickman County, some of these counties we'd never worked with before are now, regardless of the fact they have no backlog, are continuing to use mediation.
Okay.
Because they'll say, we'll talk to Amy Puckett in Hickman County, who, for her, it was a brand new world. And she said she would send us parenting cases and she'd bring them back into court and say, how'd it go? What was your experience? What was it like? And she's decided this is just a really fantastic resource for her folks.
Oh, good. Okay.
But it takes that one-on-one is what what I've realized. And so, I'm going to go on a tour.
Great.
I'm just going to go meet people.
Okay. Well, good. I guess that's what we solution then one-on-one.
Yeah.
And even if they don't have backlogs, they still need your services. I guess that's your point.
That's right.
Yeah. Okay. That's probably the way to pitch it. This is just not always COVID or not totally COVID related. It's to help any court.
It's to help any court. And now we've realized it actually is very effective even online, even remotely.
Okay.
We truly can help your people and we'll tailor it to your court, because none of these courts are going to suddenly give us 5,000 cases, right? We're not going to be overwhelmed. They're going to send a few, and we're happy to do them. So,
Maybe
yeah.
part of the message may be to redefine the ADR plan so it is a general resource for courts, not just because of COVID backlogs.
Right. And Justice Lee, that's how we have reframed it. With
Yeah.
the judge I met with, I reframed it from saying, look, put aside the backlog. Right, here's a resource for you, just like Sarah was saying, is that
Yeah.
I think a reframe is in order here. And so I'll step back and take a look at the plan too. I think that it makes a reference to the pandemic and it's very introductory. And maybe we could step back and make some changes to that and send it to you for your review.
Okay, I think that'd be great. Yeah, I do think it needs to be reframed, and maybe judges thinking, oh, I don't have much of a backlog, I can handle it. So they're just saying it doesn't apply to me, but so Sarah's information is really helpful and as to how we should reframe it and how we should proceed. And I'm from a county that never had resources, so you do get used to assuming that only applies in the big cities and not to us in the outer areas. So I like that idea.
Yeah. In hearing between the lines, to mix the metaphors, it sounds to me like one-on-one approaching the judges and basically saying, look what we can do for you is the way to go. I would think that any judge, if you approached it from a docket management standpoint, might be some bait that might be taken is you've got these various cases on your docket, the difficult cases, the construction cases, or whatever. And, we offer an option to that. And again, most lawyers, if it's a case it's very difficult or it's been hanging around for a long time, they're looking for an opportunity to at least try and resolve it. So I like, Sarah, that you're going on tour, and John and I talked about that, and he wants to be your roadie.
Be a great one.
Yeah. So, in terms of the fact that, we haven't got that many cases, but the fact of the matter is that our services as mediators, I think we're on the brink of really providing a great, valuable service in the med debt, taking it across the state for our citizens. I think that I know Sarah's got a program with landlord-tenant pre-suit with some of these large landlords. I think as we go into and what the pro bono advisory committee is talking about is that we now really start concentrating then on some of these areas where mediation can really assist the citizens of this state. I know Sarah, I know Jackie, and others have got some great programs going on in multiple counties. And that's what the advisory committee is talking about. How can we then, as a group of community mediation centers now, really come forward with a collaborative effort? And Justice Lee, what we've done is to create Resolution TN. And that is what the national organization did. We spoke with Virginia Resolution, Washington Resolution. They have funding mechanisms. And so as a result, then we are really exploring then comparables out there and working toward a collaborative effort to increase in a number of different areas. And so we're excited about that.
So it looks like we ought to officially sort of reframe the ADR plan. So it's consistent with what we're doing. At some point, is Resolution 10, is that essentially the ADR plan?
No,
That's totally separate?
Yeah, it's totally separate. What it would be is simply like in other states, and we did not know this, I called it mediation Tennessee, is that what we found out, other states have community mediation centers, but then they have an overarching nonprofit.
Oh, okay. That's Resolution TN then.
That's Resolution TN that would define, for example, we're going to have a common resource manual. We're going to have common training. we're going to focus on then those areas like med debt, et cetera. And so the committee is now getting focused on moving forward with those ideas.
That's
So
great.
there are a number of others, but
Yeah.
but the Tennessee ADR Supreme Court plan, then with your permission, then I'll make a draft. As you
Yeah.
know, I worked on that initial draft. I can change that draft somewhat and get a draft for your review.
Okay. I think I like that. I think that would shift our focus very appropriately and maybe make this more effective. And at some point, when resolution 10 is set up, maybe we incorporate a reference to that in the ADR plan and get it all consistent. Yeah, I think that'd be a great idea. And I'll submit it to the court then once you work on it, and I'll review it and then I guess the commission needs to approve it. But after that, and we have a work session in August where we're doing a lot of planning, et cetera. This would be a good time to do it if we can be ready in August. If not, I'll bring it up in September.
Well, Justice Lee, if I can give you one footnote, since that's coming up, is that at the conference, judges have talked to me about judicial settlement conferences.
Mm-hmm.
And I put the guide together on judicial settlement conferences at each stage of Pod A squared, I call it. You're probably familiar, prior, opening, during. Rule 10 needs to be amended. And so Rule 10 makes a reference to Rule 31. It's no longer Rule 31, it's Rule 31A. And so I will be sending you then information about that probably in the next day or two.
Okay, that'd be great if we can get that working then as well.
And so
sometimes the proposed rule changes need to be submitted by petition by like the ADRC. Like, tell us what you want, why, and John can help with that. And then we generally put it out for comment 30, 60 days, and then we come back and approve it. That's the best approach to getting a rule change.
Okay, thank you.
And we can work on that.
Yeah, because there are several provisions that need changed. Yeah.
Okay.
And Steve,
thank you.
Excuse me, Steve. You also have the Rules Commission as a resource as well.
I'm going to need to be led by hand now on that. I just know that Rule 10 needs to be changed.
I think, is it a Supreme Court? It's a Supreme Court rule we're changing, right?
Yes, ma'am.
I don't know if that needs to go before Rule Commission. And I'm on the Rules, I'm the liaison to Rules Commission. And I should know all this, but I think if it's a Supreme Court rule, you just bring that directly to the Supreme Court. But it wouldn't hurt to ask the Rules Commission to look at it, but I'm not sure we've done that in the past.
Justice Lee, I'll take your direction.
Well, Rick may be right. Maybe it does need to go for Rules Commission, but I'm
Thanks, Rick.
I'm not sure they do that, but I could be wrong.
No, I'm going to rewind the tape and edit out here.
Yeah, well, I actually should know more than I do about that.
I do have a couple of action items that need to be taken care of. First off, in terms of getting our wider vision to other states, obviously we've got a resource here in Linda Seeley, who is back home in West Tennessee. And in addition, we also have a new community mediation center that now we have a new ED, Vicki Krusel. I'm making a motion that we appoint Linda Seeley, the former executive director of the ABA Dispute Resolution Section, and the new executive director from Sevier County, Vicki Krusel, to serve on the advisory committee. As you know, our rule provides that we can create advisory committees and have non-commissioned members. That's been the purpose of the advisory committee. So I'm as a committee, then we're making that motion to add those two individuals to the advisory committee.
Okay. Do I have a second? Thank you.
Second.
Any discussion on Mr. Shields' motion? All right. Hearing no discussion, all those in favor of his motion to add those two individuals, say aye.
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 Any opposition? Mr. Shields, your motion passes.
The other item that needs action is that it was the Education and Training Committee made a recommendation that there be some sort of discount for those individuals who are being honored for and recognized for their pro bono work, who have met that 50 hours requirement. After further discussion among the committee, it was recommended, as I recall anyway, that in order to provide further recognition for those individuals, that they be allowed to attend the annual workshop free of charge. And
Can I just
so,
ask a quick question here on that one?
sure.
Thinking about it after we all discussed it, I would ask just pragmatically, to what degree does this training need to be a moneymaker for the AOC? And at a certain point, if we were to attain our dearest wishes and suddenly everybody was volunteering to that degree, are we happy to comp everyone?
Well, I guess my response is this. I wanted to put it, we can do this year by year. The fact of the
Well,
matter
we'll
is,
create expectations, though.
well,
Steve,
I agree
how
with
many,
you.
excuse me, Steve, how many people are we talking about? It was a relatively low number, as I recall.
Yeah, yeah.
Is it three?
Number
Four.
currently for this year
Four.
is 4.
4? Oh, okay.
So for this, we're simply saying this year, sure, comp them, but we're not making it a policy. Is that correct?
No, it's for this year. We can change it. I realize expectations, but I just think if somebody's willing to put in 50 hours, that the idea of charging them for them to come and watch themselves be recognized is simply not something that I think we ought to do. I think we ought to give it free of charge. And then I hope one day that we have 100 mediators that are doing 50 hours and that the ADRC says, you guys are really costing us money. I look forward to that day. And so right now, I'm suggesting that the motion be that those being recognized for meeting those requirements be admitted free of charge. That's
For this year, Mr. Shields, correct?
for this year. Yeah.
Okay. And then when we get up to the numbers you talked about, then we'll do the Sarah $1 discount.
There you go.
That's right.
All right. We have a motion on the table to recognize those who have more than 50 hours of pro bono service by allowing them to attend the workshop without paying any room, board, or tuition. Do I have a second on that motion?
Well, hold on, Chair, let me just, I'm not talking about room and board now.
No, I'm just kidding.
I know you were kind of joking, but
I was. A tuition waiver. How about that?
There you go. There you go.
So we have a motion for a tuition waiver. Is there a second?
A second.
We have a motion and a second. Is there any further discussion on this issue? All right, hearing none. All those in favor say aye,
Aye.
and all those opposed. Mr. Shields, your second motion passes as well. Do you have anything else, sir?
I have nothing further. Thank you, Chair.
You are welcome, sir. Thanks again. I wish I could bottle your energy. Moving to the grievance committee, and Marcus, back to you.
If I may,
Yes.
Absolutely, John.
Mr. Rudolph has represented us well. Let me answer that. As the manager of this process, we have one currently ongoing. We have an assigned grievance committee, and they are continuing along the process, and we're keeping both parties informed.
All right.
I have nothing else to add on that one. Thank you, John.
Next is Communications Committee, Ms. Gaddis. If my Zoom screen is correct, I do not see that she's here. John, do you have any messages or comments that need to be relayed?
No, not at this time. And then, of course, I'll have a comment. The only thing we've really sent out is the pre-workshop survey and save the dates to keep folks informed. And then we'll send out some additional things once we kind of solidify this agenda in the next couple of weeks so that folks can actually register.
And everybody should prepare themselves for getting a prodding to submit something for our newsletter. I am going to write something myself on the grievance procedure and try and make it a little bit easier to read so that it not only helps mediators, but it will help those on the grievance committee the next time around. There's already a flow chart, and I hope to improve upon that. I may or may not be able to do so. So please be thinking of any topics that you would like to is too strong a term, that you would be willing to write about for the newsletter. And John or I or both will be following up on that. Anything from the Ethics Advisory Committee?
No, sir. No activity in the last 90 days.
All right, sir. And Rule and Policy Review Committee, Judge Cantrell, I don't see him. So John, do you have anything on that?
No, I don't have any direction from him. Although earlier we were supposed to mention about the arbitration task force, so I'll do it here.
Please.
There's a small group. Mr. Cantrell and Justice Holder are the co-chairs, and they have a group of 3 or 4 that are also part of that team. They are working with the TBA, an analogous committee with the TBA that's already drafted up some possible rule language, a rule proposal, and they're going to consult on that and comment on it. That's about really the gist of the report.
And yes, Justice Holder is as intense as she has always been, for those of you that are curious. All right. The next Rule 31 application deadline, Tuesday, August 31st, 2021, correct, John?
Correct.
And I've got that our next quarterly meeting will be Thursday, October 14th at 3 o'clock. And John, is that going to be a combination of Zoom and in person, or just in person?
At this time, it'll be a hybrid. It'll be a hybrid. They're in nearby at the hotel or at Lipscomb University that afternoon, October 14th at 3 p.m. And we'll make sure we have Zoom up for those who cannot be in person.
Does anybody have anything else they would like to address to the full commission? All right, let me, again, I promise that I will not take much of your time. I want to thank you for the support that you've shown me in the short time that I have been interim chair. I am well aware that there are times to lead, there are times to follow, and there are times to get out of the way. And,
My favorite line.
and I hope to live by that. I certainly realize that I'm a litigator who happens to mediate cases. I do not have the experience that the majority of you have. It's been truly an enjoyable learning experience for me. Some of the words I would use to describe based upon sitting in on committee meetings are passion, dedication, diligence, and determination. And I will say that the previous leadership, Larry Bridgesmith in particular, I inherited a very, very healthy commission who has some consisting of some very dedicated individuals. And I greatly appreciate all your assistance. It's clear to me that your motivation for doing this is to improve ADR availability and the use of ADR throughout the state. And I have had the fortune to sit on a number of committees and commissions over the years. And I think I can say without much doubt that this is certainly one of the most active and thoughtful committees and commissions that I've been involved with. And you should all be proud of yourself. And that goes not just to the commission, but to John and Steph and everyone else that, let's face it, they keep us in line and keep us moving forward. So thank you to everybody. With that being said, John, if there's nothing else, do I hear a motion to adjourn?
Rick, I want to say something before
Yes,
we
ma'am.
adjourn.
Yes, ma'am.
You really chaired a great meeting today. You've risen to the occasion. We're very grateful that you agreed to serve as chair, even though it's, according to you, interim chair. But you're doing an exceptional job. So thank you. I really appreciate it.
Thank you, Justice Lee. And it's not just according to me that it's interim chair.
I do recall that discussion.
Yes, ma'am. All right. Hey, Steph. Everybody's told Steph congratulations from graduating law school, or passed along commiserations.
Thank you, guys. I appreciate it.
That's great.
Hey, I'm telling you, I've taken the Tennessee bar, I've taken the Virginia bar. Tennessee bar's nothing. I'm telling you,
Yeah.
pick up a Cliff Notes or two the night before and you're good to go.
Okay, Steph, do not listen to him.
Yes, ma'am.
As long as you can recite the rule in Shelley's case and the rule against perpetuities and know what a chosen action is, you're good to go.
You mean the one things I'm trying to avoid, right?
All right. Do I hear a motion to adjourn the meeting?
Move to adjourn.
Do I have a second?
Second.
Is there any discussion before we take a vote? Hearing none. All those in favor of adjourning say aye.
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 And I'm not even going to ask for opposition because it would make you a very unpopular person. Thank you, Sarah, for using the word pedagogus. I haven't heard that since Latin class, and now I have shivers up and down my back. You all have a great next couple of months. Is that right? Have a great summer. And if there's anything I can do for any of you all, your committees or your organizations, please let me know. Thank you.